appeal in the matter of Fatolahzadeh and London Borough of Barnet.
Yes, Phil.
Good morning, my lords. I appear on behalf of the appellant. My learned friend, Mr. Screech-Powell, appears on behalf of the London Borough of Barnet, the respondent. My lords, first of all, can I thank the court for dispensing with the need to require robes, given the heat, and very welcome. My lords, the appeal is against the decision of His Honour Judge Hellman on the 29th of July of last year, where he dismissed Ms. Fatolahzadeh's appeal against Barnet's decision, which is dated the 4th of August 2023, that they had discharged their duty under section 1952 of the Act, the 96 Act, since the address 124 Kenilworth Road, Edgware, that being the property that had been offered in discharge of the duty, was suitable accommodation, and therefore their duty owed under section 195 ceased. My lords will my lords, apologies first, my lords should have the appeal bundle, the supplementary bundle, the skeleton arguments from my learned friend and myself, together with supplementary skeletons dealing with the recent decision of this court in Norton. Great. My lords, the judgment can be found in the core bundle on the orders at page core bundle page 72, and the judgment at 73 to 91, but the review decision is to be found in the core bundle at page 118 to 130. And following the case of this court in Danesh, the principal question and the primary question is whether or not the review decision is lawful. So that's the focus, in a sense, of the appeal. The issue that this appeal raises is whether a local housing authority, where a local housing authority fails to undertake a lawful assessment and reach agreement as to the steps to be taken in light of that assessment, that being carried out under section 189A of the Act, is a decision that accommodation offered in discharge of the prevention duty, in this case section 195(2), is that a lawful decision? We can see in the review decision in the core bundle at page 129, if my lords could turn to that paragraph 87. That encapsulates the decision of the authority, namely that 124 Kenilworth Road is suitable housing, and therefore the housing duty that is owed to you, to Ms. Fatolahzadeh, has ended. My submissions are: one, that where there is no lawful assessment or agreement, there is a breach of the duty of section 189A, and in this case I say that there is no such assessment or agreement, and in the absence of that, it is not open to Barnet to find the property to be suitable in discharge of the duty, and therefore the offer that is made has brought that duty to an end. His Honour Judge Hellman.
Did I hear that right? In the absence of a proper assessment,
Yes.
are you saying it's not open to Barnet to discharge their duty under section 195?
I do.
Okay.
My lord, I appreciate that runs contrary to the decision of Norton, and I will address the court and your lordships on that in due course, because I say there are a number of factors that distinguish.
That's entirely clear. Thank you.
The decision of His Honour Judge Hellman was that Parliament didn't intend that a failure to carry out the assessment required by section 189A would invalidate the review decision, that accommodation provided was suitable, since the review supersedes any earlier deficiency or failure. and that can be found in his judgment at paragraph 56 to 58 in the core bundle at page 86. So the first question, first issue for in this appeal is whether or not Barnet failed to undertake the required assessment under section 189A. And the starting point is the in relation to the statutory scheme. My lords, if your lordships could turn to the statutory scheme, it's in the bundle of authorities at tab 15. My lords will see at page 331, the starting point in any homeless application, that is, or any application seeking assistance under Part 7, is section 184, which provides that where the authority has reason to believe that a person is homeless or threatened with homelessness, they have to make such inquiries to satisfy themselves if a person is eligible for assistance, because if they're not eligible for assistance, then they're not entitled to the assistance. And then if they are eligible, what duty, if any, is owed to him under Part 7. So that's the starting point, and what the Part 7 then sets out is the duties that would be owed under that part, dependent upon findings made by the local authority as to question of homelessness, eligibility, priority need, and intentionality. So those are factors and decisions. But the main housing duty is ultimately the duty that all applicants seek, and that is a duty on the authority to secure suitable accommodation for their occupation to alleviate the presenting homelessness. The Homelessness Reduction Act of 2017 introduced two new duties in relation to in terms of what steps had to be taken by the authority, and they are found in section 189B, page 335, and 195, which my lords will find at page 346. The duty that this case is concerned with, and the court is to consider, is section 195 at page 346, and this is known as the prevention duty introduced. And what is required when that duty is engaged is set out in subsection 1, that that this section applies where the authority are satisfied the applicant is threatened with homelessness and eligible for assistance. So the duty is engaged where there's no need for consideration of priority need or intentionality, which are the elements that would require, for example, the main housing duty. So it's only if the applicant is threatened with homelessness and is eligible for assistance, at that point the relief duty, the prevention duty is engaged. The section 189B deals with the position where the presenting applicant is actually homeless. So if my lords turn to page 135, my lords will see it's 189B, that the subsection 1 applies where the authority are satisfied the applicant is homeless and eligible for assistance. So we have two duties, new duties, one dealing with homeless and eligible for assistance applicants, and one dealing with those that are threatened with homelessness and eligible for assistance. Turning back to the duty, the prevention duty, page 346. Where that duty is engaged, the duty that is imposed is found in subsection 2, and that duty is that they must take reasonable steps to help the applicant to secure accommodation does not cease to be available for the applicant's occupation. So they have to take steps to effectively avoid the applicant from becoming homeless, i.e. without accommodation that's suitable.
Reasonable steps.
My lord?
Reasonable steps.
Reasonable steps, of course, indeed. Reasonable steps. And the same applies in terms of the duty. We can find for the relief duty at page 335 in subsection 2 that they've got to take reasonable steps to secure that accommodation is available. So a similar duty. And then in subsection 3, page 346, the Parliament requires that in deciding what steps they are to take, so reference back to the reasonable steps my lord referred to in subsection 2, the authority must have regard to their assessment of the applicant's case under section 189A. And flipping back to the 189B, the relief duty, a similar duty is imposed in subsection 3 in the relief duty in deciding page 335, in deciding what steps they are to take, the authority must have regard to their assessment of the applicant's case under section 189A.
So the duty to be discharged is the duty as expressed in section 1952 and 199B2.
Indeed, my lord, that's right. That's the duty.
That's a critical question.
That is. And in discharging that duty, they have got to have regard to the assessment that they have to take to undertake under 189A. So that's what subsection
section says.
My lord.
We're concerned with the consequences.
My lord, that's quite right.
Can I just be clear?
My lord.
In paragraphs 52 and 53, the judge held that there was an assessment, but it was deficient as to reasons for location, particularly for location.
My lord, yes.
So this appeal is proceeding, I think, but I just need to be clear, on the basis that there was a failure to do what they were required to do in terms of creating an assessment.
Yes.
But then there was a review process.
Yes.
In the course of which I think two things may be material. One, the inadequacy of the assessment was not raised,
Yes.
either directly or indirectly. And two, there is no separate complaint about the review process. There's no attack on the review process. As expressed in your grounds of appeal,
yes.
It's a pure point of law.
Yes.
If there's something wrong with the assessment at any stage,
yes.
or the treatment assessment, everything else falls.
Indeed. My lord's right. I mean, there was an attack in respect of location, because that was an issue that was
exactly.
But it was raised on appeal. It was dismissed, and permission isn't sought in respect of that finding of the judge that there was no error of law in terms of their assessment of suitability.
Apart from their failure to identify that there had been a failure to recognise this.
My lord, yes.
Okay.
My lord, the reason I'm taking the court to the sections, subsection 3, is because that requirement is unique, is express and is unique in the context of the relief duty and the prevention duty. It's also there's also reference in section 190 for there to be there's a requirement to consider the assessment, but one doesn't see the same requirement in section 193(2). Section 193, which is the discharge of the main duty, and that's a point that Lord Justice Lewison makes, and we'll come on to that in the question of Norton. So there is an important difference in that Parliament that requires local authorities, when discharging their relief duty or their prevention duty, to take into account the assessment under 189A. And
is it your complaint that they did not take it into account?
My lord, my complaint is that there wasn't a lawful 189 assessment.
That's a different point. That's my. So are you saying there's a breach of subsection 3? What that says is the authority must have regard to their assessment
Yes.
under section 189.
The assessment has to be a lawful assessment. If there's not a lawful assessment,
What's the authority for that?
because if one looks at what the well, there's no authority for that
Well,
other than what this
you
court's
say
going to
that,
decide.
you might have said, actually, that's fundamental public law principle,
Well,
Sianas Minnick.
My lord, and well, Parliament requires the authority. If one turns to section 189A and see what is actually required, and then what I propose to do is take your lordships, for example, to the Code of Guidance, and the purpose of the legislation and the reason for is to engage, for local authorities to engage and collaborate with applicants at the very outset of the application, so that it provides the roadmap that will then be used for determining how any duty is discharged.
Yeah, but the difficulty for you may be this, that if they don't do a 189A assessment at all,
Yes.
then Norton appears to hold that that doesn't matter.
Well, my lord, I say that section 189A isn't an option.
Right.
It's not an option for the local authority to say, well, I can if I don't do an assessment, I can't be criticised for not taking it into account. Therefore, my review decision on suitability is just dependent upon the circumstances as at the date of the review. So to avoid the duty, following Norton, it's now open for local authorities in a 193 discharge to say, well, it matters, it's a breach of no consequence, because suitability reviews overtake and deal with all issues that are relevant, and there's no loss to the applicant. In my submission, if that were right, then effectively the changes that have been introduced and the reason for the changes have been.
Well, you say if that were right, Norton is binding on this court. So well, even if we thought it was wrong,
yes,
that's nothing to do with us.
Well,
we have to follow it.
The Norton, that's why I say Norton, when one looks at the facts, because of the effect of subsection 3, where there is a mandatory requirement, and Lord Justice Lewison does, I can take your lordships to the paragraph if you wish now, but he distinguishes.
You take your course and don't let us throw you off course.
I'm quite happy to be moved along if I can assist the court. But
it would help me to look at section 189A first. But clearly, you've got to explain to us why Norton, why we're not. This decision isn't determined simply by Norton.
Yes. I accept that.
You're going to say that it isn't.
Exactly, and I know my learned friend's going to say, well, Norton ties your hands, and therefore you must reach the same conclusion as Norton, namely that suitability reviews overtake any breach, and there's no ill effect of the breach, and therefore the decision is a lawful decision.
But this judge recognised that if you don't have if you have a deficient assessment or no assessment at all, or if you don't have regard to your assessment, that may lead you to take steps which are not reasonable steps. So it may lead you to a failure to discharge your duty under Section 192.
Yes.
So that's the crunch, isn't it?
It is. It is.
So if for example an applicant confronted by a decision says you're not taking reasonable steps, or this is not suitable because you haven't taken into account, let's say, location or medical or whatever it may be, that's the protection for both parties, because if the applicant can demonstrate that the assessment is deficient or was not consulted, that's a good start.
Mm-hmm.
But then if the housing authority can say, but the steps we took were reasonable, look, you're in suitable, suitable, you've been suitably housed, then we get back to what my lord was saying about it doesn't matter. It does matter, but the end result is you don't upset the whole process.
The reason why I say, and my lord, I'll come to the section how what is required by the assessment. The reason I say 189A is a important duty, because it's a duty to complete an assessment, that is because it provides, using Lord Justice Lewison's words, it provides the roadmap. I prefer the phrase roadmap as opposed to nuts and bolts, because the roadmap identifies what accommodation, what steps can or should be taken, need to be taken for an applicant to avoid either to avoid being homeless or to relieve homelessness. And therefore it sets the parameters, and effectively the horse is in front of the cart, and it leads that it determines the direction. And when once the assessment has been completed and the steps that are to be taken identified, then when it comes to matching properties, which is invariably done by a different officer and on a different team, because they've got the knowledge of what accommodation is available, and they have to then match the applicant to, or the homeless person to the property. They will use this roadmap when it comes to offering the accommodation and questioning of questioning suitability and reviews of suitability of decision of offers. Then the roadmap provides the parameters within which another officer is going to be looking at. Well, this was what's agreed by the parties right at the very beginning. And it works both ways. It helps both the local authority and helps the applicant.
Your use of an analogy of a roadmap is quite interesting, because a roadmap helps you get to a destination, but sometimes you can get to the destination without following the map. Is it? I mean, that may sound a flippant comment, but really what you're saying is there are certain hoops which the local authority has got to go through.
Yes.
It's not just a roadmap which helps it get to a destination.
It helps. The reason I say it's a roadmap is because at the goal is to either prevent homelessness or to relieve homelessness. So if somebody has no accommodation, then the roadmap identifies the housing needs, so that when it comes to matching a property with to an applicant, if, for example, the roadmap says the applicant is wheelchair bound, it will say has to be ground floor or lifted properties. So that if there's no roadmap, he could be offered accommodation on the fifth floor of an unlifted block.
For example.
Yes, my lord.
Say an assessment is done. You've got a single document. It's headed assessment.
Yeah.
And it fails to say of the applicant wheelchair bound.
Yes.
What should happen then?
At that point, then because when we get to 189, there has to be an agreement between the parties as to what steps to be taken based upon the assessment. If it's properly done, the applicants can say, well, actually, you're wrong here because I'm wheelchair bound, and you've got there, I can be accommodated in any accommodation unlifted. That's clearly not going to work. So there's also the provision within the section of reviews. So, for example, if the applicant becomes wheelchair bound after the first assessment, there should be a review of that assessment to then again to tailor the parameters for the officer who ultimately makes the match, and then ultimately the other officer who then carries out the review. Now, if there is no assessment and agreement or provisions set out in writing, identifying the steps that have to be taken or should be taken by both the local authority and the applicant, then when it comes to a review, the cart, if my Lord Justice Lewison is correct, the cart goes in front of the horse, and the breach and the failure to carry out the assessment is inconsequential, because the suitability of the accommodation, given the factors and the issues and the material circumstances, will determine whether or not the duty is discharged. I.e., the assessment, the roadmap, is of no value.
In this case, there was a PHP.
Well, in this case, there was.
And no one picked up.
Well, I'll come to the PHP.
Complaint about, or the deficiency in the assessment. That is that. So there were two things. The note of the 21st of September
Yes.
interview was sent.
Yeah.
And then they proceeded to PHP,
Yes.
where the deficiency upon which now everything is said to fall into dust was not identified. They proceed to make an offer of property, which is accepted. She then challenges suitability. Fine. There's a review
Yes.
of the challenge to the suitability that has been identified, or the absence of suitability that's been identified, and there's no criticism about the outcome of the review.
Sorry, my lord.
And this is all then hinges on the failure to pick up in inadequacy of the assessment at an early stage.
My lord, it doesn't just hinge on the failure to pick up. It hinges on the failure to discharge the duty. And what is the effect of the failure to discharge the duty to carry out an assessment?
The duty, there's two different sorts. There's duties and obligations. I prefer to talk section 1952 talks about the duty, and there is an imperative obligation imposed to have regard to the assessment.
Yes.
If you're right, if for perfectly legitimate reasons, human frailty, whatever it may be, the deficiency in the assessment is not picked up at the PHP stage, it inevitably vitiates everything that follows, even if it's accepted at the end that the local authority has taken reasonable steps and has found suitable accommodation.
My lord, in the absence of the assessment, a lawful assessment, in my submission, that does vitiate the
Lawful meaning fully compliant in every respect with which what you say should be.
Yes. Section 189A.
It makes the process of providing assistance absolutely unmanageable.
My lord, with respect, my lord, I would
I suggest.
The reason, I mean, if I agreed with my lord, I'd have to sit down. But I mean, if the reason I say that it doesn't make it unmanageable is because the whole purpose of the introduction of the introduction of the requirement to carry out the assessment is to bring the applicant and the housing authority to work together to seek to avoid and to relieve homelessness, as opposed to the current the system. The procedure prior to that, namely, you make an application, the authority conduct inquiries, it becomes more adversarial, the applicant engages less, and decisions are made which are adverse and reasoned and then challenged in court through 204 appeals and further. Now, my lord, the purpose of the introduction requiring the assessment is to, in my submission, to bring the two parties together, to give the applicant the voice in terms of determining what their needs are and what steps are to be taken by both the applicant and the authority to put it in writing at the very outset of the process, and then for that then to be taken into account when determining discharge of duty. Now, if it is the case that the requirement to conduct the assessment is a requirement that where failure has no consequence, then the local authority can quite easily and quite safely say, I will not carry out the assessment, and if I am judicially reviewed for failing to carry out the assessment, I can say, well, the courts, the decisions, the way the scheme is to be interpreted is that suitability trumps the breach, and therefore, and the failure. So therefore, given that we have decided that the accommodation is currently suitable, and when we come to discharge at the next stage of the process, because it is a process of providing accommodation up until final discharge, they can say, well, we will review it then and decide whether or not accommodation is suitable.
If they just say suitable, I'm sorry I'm intervening so much, but I need to get this clear in
My lord, yes.
If they just say suitability trumps assessment, they'll lose. What they might be entitled to say is, despite any deficiency in the assessment, or treatment of the assessment, we have in fact taken reasonable steps in discharge our people. That's at the moment I can't see anything wrong with that.
Well, my lord, the reasonable steps have to be measured according to the assessment.
Mr. Colbert, we've I think you were still taking us through the
I
legislation.
indeed have remembered. I'm going to my conclusions a bit.
There's a lot that
Indeed.
I would like to ask, and my lords would like to ask,
Indeed.
but perhaps we should let
Maybe
you
I
get through the
can wind
legislation.
back a bit. I can pick up on the. I hope that when I go through the facts of this case, then the points that my lord raises will.
Yeah, you carry on with the legislation.
My lord, can I take you to the assessment 189A? Good. My lord will see page 333. The assessment is that the requirement to carry out the assessment is engaged where the applicant is homeless or threatened with homelessness and eligible for assistance. So once you get to that, once the authority are come to the view that they are homeless and or threatened with homelessness and eligible, they must make an assessment. Subsection 2 identifies the three matters that have to be expressly considered within that assessment. Firstly, the circumstances which caused the applicant to become homeless or threatened. So it's looking backwards, looking at what are the presenting facts that they are homeless or threatened with homelessness. And then B is looking forward. What are the housing needs of the applicant? And in particular, what accommodation would be suitable for the applicant or any person who's a member effectively of their household. So it's looking forward and saying what is the housing needs of the applicant, and in particular, what would be suitable accommodation. And then thirdly, what support is necessary for the applicant to be able to either have or to retain. So what support needs to be given and built in to ensure that the accommodation that has been identified as what their needs are and what would be suitable, how is that going to be achieved? So it's not just a wish list. It's actually with the steps that are required to be taken being identified. It's positive. It is a plan, as I say, a roadmap providing clarity and practical steps that have to be taken to achieve the ultimate goal, namely the provision of suitable accommodation.
Now, as you said, Mr. Colville, this is expressed in mandatory terms.
It is.
This is not a discretion.
Not a discretion.
This is mandatory.
Indeed.
So these are public law obligations, use of them. Right, fine. What if you have this stage? You haven't got any further. You pause at this stage of the process. Would that and somebody wants to argue that is a deficient assessment?
Mm-hmm.
Would you be able to apply for judicial review?
Yes, you could do. Indeed, and that's what the cases of X, Y, and so on in the bundle are cases where challenges are brought for failure to discharge, to undertake the assessment.
Well, normally, what the administrative court would say is that although the decision is amenable to judicial review, we're not going to give you permission to challenge it because you have an adequate alternative remedy, which could be a review, for example.
Well, there's no right to review of this decision.
There's no right to review this
So you can't appeal to the county court. It's only section 202 sets out the decisions, and this is
okay. Fine. All right. Let's take that as a given. Okay. If you haven't applied for JR of this decision, can you challenge it later? Indirectly, in the context of some other decision.
My lord, yes, in that the duty under subsection 9 continues until it's been finally discharged. The duty under Part 7 is finally discharged. I believe that's the section.
Right, but that is, with respect, that's not answering my question, because you would still then
So
be
to-
challenging. You would be challenging the deficient assessment.
Indeed. But it's a
You'd be
continue.
challenging the later decision.
It's a continuing duty. It's a continuing requirement to keep under review the assessment that has been carried out. So you just can't just park it and say, well, I've done the assessment on day one.
I'm not explaining myself clearly.
Sorry, I apologise.
It's my fault. Okay, fine. Suppose somebody says, for some way down the line, I should draw your attention to subsection 9. You are in breach of subsection 9.
Yeah.
But that isn't. That would be challengeable by way of judicial review on your submission.
My lord, yes.
Yeah, but that isn't what you challenged here. That's the problem, isn't it?
What I'm challenging here is that the decision that the accommodation is suitable and therefore discharges the duty is not a lawful decision, which is amenable
I
to.
understand the argument, but all I'm asking you about is whether you could have challenged an alleged breach of section 189 capital A, whether it's the earlier provisions or whether it's the continuing provision in subsection 9. And I think you've said, yes, in principle, you can challenge that.
Once the decision is made that the accommodation is suitable and discharge of the duty, then the duty comes to an end. The right to appeal on that decision lies to the county court, and part of the ground of appeal on that is that it wasn't open to the local authority to decide that their duty had ended because the accommodation, in the absence of the assessment under 189A, it wasn't open to the authority to conclude that it was suitable in discharge of duty.
No, I understand all of that.
Yeah.
And I understand what the jurisdiction on appeal is.
Yes.
But I'm interested in points of principle,
Mhm.
whether in principle a person could challenge the deficient 189A assessment, either at the outset, because they say this is deficient. I'm not happy about that. I'm going to challenge it. I can't appeal to the county court because that's a more limited jurisdiction. So I'm off to the administrative court. That's where the residual judicial review jurisdiction still vests. And I'm not. And subsection 9, I'm alleging that you've breached your continuing duty to keep the 189A assessment adequately under review. Now, I may or may not be right on the substance of the case. All I'm asking you is, could you, in principle, go to the administrative court and say, I want to challenge that?
Where the authority have decided that the accommodation is suitable in discharge of duty, and then there's a right to request a review of that, then I would say that at that point there would be an alternative remedy because you can raise the point in the county court.
That's if you reach that process. If you reach that stage of the process.
Yes.
But I'm asking you
Prior
about
to that, then it's a judicial review.
Yeah, exactly. Now, suppose you haven't done that. Right?
Oh, yes.
So you've had, at least conceptually, you have had the opportunity
Yes.
to JR
Yes.
the assessment because it's deficient or it hasn't been adequately kept under review, and you haven't done that.
Yes.
Right? What is public law then to make of that? Should that be taken as something which you can indirectly challenge subsequently when you're in fact challenging something else, or does public law take the view, well, that's it, you're stuck with that? That's now a valid decision in law.
Prior to the decision which would then engage the right to appeal, a right to request a review and then appeal, so i.e. the alternative remedy. Prior to that, then the applicant would be able to judicially review the inadequacy of the assessment.
Yes.
Which would then feed into the decision as to what is suitable in discharge of the duty.
Yeah.
My lord,
that's 189A, is it?
Right. My lord, can I just
make one? Sorry, forgive me.
Yes, my lord.
I know it's having three different people to respond to isn't always easy. But I'm struck by something you said right at the beginning. You emphasised the word assessment and agreement.
My lord, yes.
So that's caused me to look on through section 189A.
My lord, I'm just about to
And
go
as I
through
see
that.
it, there are a number of duties under 189A, the first of which is to carry out an assessment.
Yes.
And there are more than the ones I mentioned. And there's one to notify the individual of the assessment.
That's right.
under
3.
3.
Yes.
Then there's the endeavour to enter an agreement provisions, which follow on 4 onwards.
Yes.
And then there's the keeping under review provisions further on, the one we just looked at 9.
9. My lord, yes.
You're going to argue, are you, just so I can anticipate it, that they are all relevant to the section 195 duty?
Yes, because they have to. This is the first step to be taken when an applicant presents. They've got to, if they're homeless and eligible for assistance, the authority have to assess. Carry out the assessment under subsection 3. They are required to notify the applicant in writing of their assessment. That's no agreement. It just they have to notify them of what their assessment is, and the assessment has to cover the 3 matters identified in subsection 2.
Yes.
For it to be lawful. And then after the assessment, there has to be an attempt to reach an agreement with the applicant, which again has to be in writing. About the steps that have to be taken by both the applicant and the authority to secure that the applicant has or is able to retain suitable accommodation. So those steps would have to be set out in writing.
And you're going to say, are you, that all of those matters fall within section 1953?
Yes, I do.
I note that it doesn't say that, but no doubt we'll come on to that in a moment.
1953.
Have regard to their assessment.
Indeed, their assessment. The assessment is, in my submission, both the assessment of the 3 matters and what are the needs, but also how the plan is, what steps are to be taken to implement that plan. That's
the way 195A is drafted suggests that the assessment is the first process, 189A 1, 2 and 3, and then subsection 4, after the assessment has been made, the authority must try to agree with the applicant, etc.
My lord, yes.
So
my primary submission would be that the following XY and the decision of the court, lower court in that case, both the assessment and the steps that have to be taken they don't have to be 2 separate documents. They can be 1 document. And indeed, in this case, when we get to the facts, there is just the 1 document, and that invariably that's what local authorities do. Is they just complete 1 document, which is called the personalised housing plan, and that's and so that's the document that is produced in discharge of the requirements of section 189A.
Yes. Now, is there anything else in the legislation you want to show us?
My lords will see in terms of the steps that have to be taken, and if not agreed, then the authority are able to set out the steps that have to be taken, but they must record in writing why they couldn't agree.
Yes.
So they must, if there is no agreement, they must explain why there is no agreement and give the reasons for that. So again, it's all crystal clear right at the outset, so that when another officer picks up the section 189A assessment and plan, then they're able to identify what it is they're dealing with in terms of the individual and the requirements.
Is it significant that 1953 does not refer to the agreement or record of agreement or record of non-agreement?
My lord, I would say it's not significant in that, given that the assessment and the steps are inextricably linked. The link between the identified need and the how to alleviate how to alleviate, because if one looks at 2C, what is included within the 2C is what support would be necessary for the applicant to be able to have and retain suitable accommodation. So it's looking at the practical, what support is needed. And that's where the steps come in, because that identifies what the steps are that need to be taken by both applicant and by the local authority to ensure that suitable accommodation is either obtained or retained. So there is a link on I4, I say, that the distinction that my lord has referred to, namely, it's just the assessment, not the steps, and the agreement. I say that there is that link between both through subsection 2C, thus meaning that the whole document, namely both aspects, are required to be considered. It would be, in a sense, practically thinking it through, it would be inconsistent to just have to take into account the assessment of the needs, but not be concerned with the steps when deciding whether or not the duty is discharged. They both got their hand in glove. My lord, the review is the subsection 9 is not conditional on the matter being raised by an applicant. It is a requirement imposed on authorities to keep it under review. And if they carry out the review and change the plan, then subsection 10, any changes have to be either agreed or, if not agreed, again, notified. So that's the scheme. If I can take my lords to the Code of Guidance, just so that my lords can see what the Secretary of State has as tab 18. Chapter 11 deals with the assessment and the personalised plans. And this is the Code of Guidance under section 182, which the authorities have to have regard to when making decisions under part 7. And paragraph 11.2, it makes it clear that the 189, the section 189A duties to assess provide the framework for housing authorities and applicants to work together. Housing authorities should adopt a positive and collaborative approach toward applicants, taking into account personal particular needs and all reasonable efforts to engage in cooperation, their cooperation. And then turning over the page to paragraphs 11.8 and 11.9, that deals with the circumstances under 2A, giving guidance as to how the authorities should be approaching it. 11.10, that deals with the looking forward in terms of identifying the housing needs, and in particular, this will include the assessment of the size and type of accommodation required, any requirements to meet the needs of a person who is disabled or has specific medical needs, the location of the housing that is required. The applicant's wishes and preferences should also be considered and recorded within the assessment. So it shows that there is a wide, the assessment and looking at identifying the housing needs includes identifying all relevant factors, providing guidance to the both future officers when reading it as to what is considered to be accommodation that will meet the individual's needs, and indeed going as far as saying, well, this is the wish and aspiration or preference may not be agreed, but it's what they so the officer is actually knows that the what the applicant would like. So again, it shows working together. And then finally, paragraph 11.11 in terms of the assessment of the support needs in terms of being holistic and comprehensive, not limited to those needs which are most apparent and or have been notified to the authority. And the need for sensitivity in seeking to identify what support is needed and should be obtained in order to achieve the goal of suitable accommodation.
Suppose, Mr. Colville, the assessment fails to record, for example, the wishes and preferences of the applicant.
At that point,
Sorry?
if it fails just to record wishes and preferences,
Okay.
I wouldn't see that as being arguably a deficiency in the assessment, because it's not a part of the agreed. It's not identified. It's only a wish or a preference. So, for example, a wish of a rose bed in the front garden. That's a wish, but it's not. It's clearly immaterial to the assessment of suitability. So, would a challenge be quashed? Would a decision be quashed because the plan fails to identify the wish? My lord, I wouldn't see that. But what is needed is identifying what are the housing needs and how those needs are to be met. That's what the plan has got to identify.
Section 189A2.
Yes.
So, I mean, I'm sure we can trust you to say you wouldn't rely on failure to record wishes and preferences. That's fine, but I'm not sure about everybody else in the housing market. The critical thing is subsection 2, isn't it?
It is.
Rather than the guidance, which
I
is...
I appreciate the guidance is only guidance. It's important in terms of because they have to have regard to it. It's not a mandatory. You must follow the guidance. That's section 182, which is in the bundle, subsection 1. But my lord, what the guidance does show is how what the purpose of the assessment is for, and how local authorities should be conducting themselves in engaging with applicants, working with them, collaborating with them, drawing up the assessment in writing, notifying them, and then agreeing the steps that have to be taken to meet that. Now, if the applicant says, well, I don't agree with your assessment, so I don't agree with the steps that you say that have to be taken by both you and by myself, then that's where Parliament have stepped in and said, well, the authority doesn't have to isn't bound to get the agreement. They can say, as long as they say in writing the reason why there is no agreement, and that's because, for example, they wouldn't agree to the steps because they required a house with a rose bed in the front garden. That would be a reason why they couldn't reach they reasonably not reach an agreement.
Right. So have we finished with the code now?
Finish with the
That's
code.
the code.
But you haven't. I'm just checking on. There is a further chapter in the code on the prevention duty,
There is. I haven't included.
which you haven't included.
I haven't included that.
I was just checking if there is one. There is one.
There is one. I can.
Obviously, neither of you thought it was relevant to.
My lord, no. I can make a copy available for the court just so that you're for completeness. So that is the statutory scheme. Can I take, my lord, just briefly to notes, and rather than going and dealing with it in substance, Lord Justice Lewison at paragraph 31
Yes.
page 322 of the bundle, said, I do not doubt that an assessment of suitability based on an unlawful or otherwise legally flawed assessment under 189A is itself legally flawed. But where these cases, and that's reference back to the cases of XY and Haringey, YR and UO, those are the authorities which deal with the requirements and the failure to discharge the duty. what those cases don't address is whether the authority is precluded from independently and lawfully assessing suitability in the absence of the 189A assessment or the plan.
Now, can we just pause there?
My lord, yes.
Because this is why I was a bit surprised when you conceded earlier today that Norton is against you. Because I thought you were going to say that
Well,
first sentence of 31 is in your
it's
favour.
against me in the sense that the conclusion is that, well, suitability review overtakes the absence of a the defect and failing to provide.
Well, maybe so, but what 31?
Sorry.
I may be wrong,
Oh.
which is why I need your help.
Yeah.
The way I read paragraph 31, what Justice Lewison is saying is that what the earlier cases which he had summarised do not address is whether an authority is precluded from independently and lawfully assessing suitability in the absence of a section 189A assessment or a PHP. In other words, the factual scenario which was before the Court of Appeal in that case was where there was no 189A assessment. I understand.
There was no 189.
Yeah.
There was a 189 assessment.
But why is he then posing the issue as being in the absence of a section 189A assessment?
My lord,
That's why I need your
the
help.
reason I say there was a 189 assessment is because, sorry, there was an assessment. If my lords go to paragraph 22 of the page 320. And then, my lord, at one flips over to page 327, at the
Right.
top of the page, carrying over from paragraph 46, carrying over the page, it is not suggested that the reviewing officer was based on a flawed housing needs assessment. The point taken on Mr. Norton's behalf is purely procedural.
This is what I'm really getting at, that both that passage and the first sentence of paragraph 31 appear to support you.
My lord, yes, they do.
Well, thank you.
They support me, but the conclusion that Lord Justice Lewison reaches is that the breach is a breach of no consequence because Parliament didn't intend for that breach to vitiate a suitability decision, because the suitability assessment on review overtook.
You may be right, but the way I read the first sentence of paragraph 31,
It supports me.
sorry, can I just finish?
Sorry.
An assessment of suitability is itself legally flawed. Well, that doesn't seem to be saying it doesn't matter. It supersedes everything that's gone before. It appears to be saying the reverse, that the assessment of suitability is legally flawed. But you may say that I'm not reading that correctly.
My lord is reading it correctly.
The other side will say I'm not reading it correctly.
What Lord Justice Lewison doesn't say in that sentence is the nature or significance of the flaw. He goes on to say, we now look at the significance of the flaw, and it's not a flaw that vitiates what comes after.
Basically, because Parliament didn't intend it.
Yeah. So
That's why.
Yeah.
Sorry.
the first sentence on its own,
Yeah.
so far as it goes, taking the rough with the smooth, is in your favour in that there is a legal flaw because, can you confirm whether I've understood this correctly on your case? There's a legal flaw because it should have been reached having had regard to the assessment.
Yes. And there was,
And because you haven't, in that respect, it's legally flawed.
because going back to paragraph 22, there was an reading. Just not, I don't know the particular facts, but reading the facts in the judgment, there were clearly a judicial review brought against the failure to carry out a review of the assessment, and that was compromised on the basis that Haringey would prepare a revised housing needs assessment. No assessment was prepared before the reviewing officer made its decision to uphold the suitability, and therefore, so the challenge was therefore that the suitability decision was unlawful because there was no updated review, and that's. My Lord is right in saying that Lord Justice Lewison goes on. If Lord Justice Lewison stopped
At the end of the first sentence, you'd be delighted.
I'd be absolutely delighted, because I would say that my point has been proved and accepted. But he goes on to then question, did Parliament intend that? And his conclusion, and the court's conclusion was the court didn't intend that. And I'll come back to his reasoning in due course. But my Lord is quite right. That paragraph 31 supports my analysis.
First sentence.
Read in isolation.
Read in isolation.
Yes. But the analysis in fact goes on to say under imperative requirements that it all turns on well-known authority like Snagey and A1 properties.
A1 properties.
Yeah.
Yeah. And so having in a sense set out the stall that the requirement, the assessment would on the face of it render the suitability review decision flawed because there's no, in the absence of a lawful assessment, that flaw in a sense is of no effect.
Right.
And that's where my Lord, Lord Justice Lewison swings against me.
Yes.
Because of his interpretation and the court's construction of how the requirement is to be read. And I've come to a reason why I don't believe this court. I would submit that this court isn't bound by that decision in a moment. But the Lord Justice Lewison does refer to, indeed, cites the passage which I've referred to in my argument, paragraph 51. Sorry, paragraph 25, paragraph 51 of XY, and the importance of the duty imposed by section 189A, and the need, clearly an important duty, as it informs the nature of the accommodation that must be provided for the applicant as well as the support needs to retain that accommodation. The assessment does not, my judgment, have to deal with everything, but just setting out the nuts and bolts. My Lords, I more readily adopt the roadmap approach as opposed to the nuts and bolts, because roadmap makes it clear as to what purpose of the plan is. My Lords, turning to the question then is what assessment was undertaken by the authority, Barnet. The applicant first presents, the application that led to the decision as to that there was a relief duty owed. She first approaches the authority according to the review decision on the 29th of July.
Are we still in Norton, or are we looking at the present?
My Lord, we're just moving on to the facts of this case. I'll come back to Norton in a moment, if I may. There was then the interview, which my Lords will find in the supplementary bundle at page 247. I can ask my Lords just to turn to that.
I'm so sorry, Mr. Cole, I missed the reference there.
The supplementary bundle, page 247.
Thank you.
Could you confirm that, are you going to page 247?
Yes,
So, as I understand it, the note of the interview starts halfway down 247
that's right, my Lord.
and goes to
252.
Where does the note of the interview finish?
My lord, I believe it
Is it 252?
252, my lord, yes.
Below initial inquiries.
Yes.
Right. And that is said by the respondent to take the place or to be an assessment, or to at least to be a constituent part of the assessment,
Yes.
which the judge has found was deficient as to location.
My lord, if we can go through it, yes, my lord, but if we look at the actual interview itself, you can see what was addressed, considered.
Yes.
And my lord will see, so if we start firstly at 247, the interview starts under the heading of 219022, identifying the applicant and her son, the address, the reason for the homelessness at page 248, being the service of a section 21 notice on her for which she has there would be no defence. Current presentation, explaining there that where she's come from and the nature of the tenancy she resides there with her son, and she's required to leave by the 26th of September. It's a 2-bedroom property. Details given regarding the property, the rent, the issues of disrepair, the agent, the whether there was an EPC or a gas certificate. Looking at the residential history, looking backwards and saying, well, she's been in occupation since 2014 at the address. Suitability at page 249. Underneath that, employment, no, parking account, etc. Debts, no. Education relating to her son, and it's online. Any special educational needs are there's page 250. Her son is deaf. Benefits that were received. Then we have questions and inquiries made regarding the medical issues for both the applicant and her son, which goes over the page 251. Then we have the risk assessment. Is there a reason, any unsafe areas and allegations of domestic violence, etc.? And the answer to all those questions is no. Further suitability assessment support network. So it identifies that Ms. Fatolahzadeh has the support of a friend who assists her and her son with their needs and provides support weekly with shopping appointments, cleaning of the house. So and then some general matters, and that is the extent of the interview. So so it was following that interview that the 253. Then at page 253, there is a post-interview declaration form, which has been signed by on the 26th of the entry for the 26th of September, and then uploaded.
Forgive me for asking. The mechanism of having an interview, which clearly is meant to cover most bases, sending it post-interview declaration form, is that meant to be the production or the generation of the assessment and the agreement of the assessment?
My lord,
you may say it's deficient,
yeah,
but is that the way that local authorities do it?
My lord, no. Each authority will do different. Each authority will have their own way. This is just, as I read this interview for the 21st, is collecting information about the reasons for homelessness and the personal circumstances of the applicant. It doesn't address the question of what are the housing needs, and it doesn't address the question of the steps to be taken.
Well, that I understand, that you say it's deficient.
Yes.
And for our purposes, what matters, the judge held it to be deficient.
Yes.
Whatever. But what I was really asking was whether this was the way that some, not necessarily all, authorities go about at least laying the ground for their assessment.
My lord, I haven't experienced this way of being done. by other authorities. Effectively, this is a telephone, as I understand it, a telephone interview with a electronic confirmation following on from. That's as far as it goes. But that's what led to the service of the prevention duty. If I can take my lords to the page 19 of the supplementary bundle. So this is the letter of the 26th of September. We've carried out an assessment to see how we can help. Outcome is that you're eligible and satisfied you're threatened with homelessness. Your PHP, the personal housing plan, is either attached to this letter or will be sent to you shortly. It is important and contains our assessment of your housing circumstances, needs and support needs. Sets out the things we discussed that can be done to help you from becoming homeless. We want to do everything we can to make sure you don't become homeless, and this plan confirms the actions we discussed and the steps we need to take together. Please note you have the right to request a review. And then on the next page, page 20, this at the bottom of the page, accept confirmation of the acceptance of the relief duty. This notification letter refers to an assessment of your housing circumstances, needs support. The written outcome of this assessment required is set out in the personalised housing plan. The personal housing plan issued either with this notification or to follow, which meets the local authority's duty under section 189A and contains and then sets out what what it's required to contain, taken from the Act. We turn to page 222, which is the actual document, the personal housing plan referred to. Now, I'm not entirely sure whether it was attached to the letter or there appears to be an email at page. I'm not totally on it. Your Lordship, Stuart, page is dated the 12th of October 22. That references supplementary bundle at 256.
256, did you say?
My lord, yes. It appears to have been emailed on the 12th of October. But
what was the page of the PHP itself?
the PHP is at page 22, my lord.
Oh, sorry, I got the wrong reference. What do you want us to look at in that?
My lord, the plan starts. The assessment of your housing needs was undertaken by Ms. Cork on the 21st of September, so it's referenced back to the to the interview that we just looked at.
Yes.
And as part of the assessment, this what they have taken into account, and then in terms of the basic information, it's noted within the plan that the reason for approaching Barnet was because of the Services Section 21 notice. Page 23, likely to become homeless on the 26th of September. Look, what actions taken already? Stated you've been looking for temporary or looking at private rented properties. You need assistance with long-term accommodation, and then actions and steps, reasonable steps to be taken. And we see that is then set out in what steps should be taken by the by the applicant and by the council. Then following that, there is it's a pro forma that's been completed, but not specifically tailored towards the applicant. Indeed, there is nothing in. If I can take Lordships to page 30 at the end of the general advice that's been given, it states that the plan would then be reviewed on the 21st of October of 2022. And finally, the checklist of additional information required is then set out. What I say is that that is the extent of the plan. That is the extent of the assessment that was that Barnet carried out, and it clearly does not comply with the statutory requirements because it fails to identify what the housing needs are and fails to identify the steps that we can take that should be taken to meet the identified housing needs.
And that was covered subsequently by the recommendation for the medical team, who said
Then there's further. There's the banding letter, which
do you say that's of no significance?
That's post the post the PHP or the assessment. There's been so there's been no compliance with the requirements in terms of reaching agreement, putting it in writing, reaching agreement, and my lord, that's the authority, and there was no review, even though they said that they would carry out the review. And indeed, when they received the medical information, when they received the banding, if I go to the banding letter, my lords will find that at page 34 in the supplementary bundle. What is identified in the banding letter is that a property will be suitable if it's no more than 2 bedrooms and your housing needs are the first floor maximum or lifted with a shower with a seat. So that's the extent of the criteria that are.
And she was invited, if she did not agree, to contact to explain why, and did not do so?
Yeah.
And
so should that be taken as agreement?
My lord, no, because this is an offer. So this was a decision based on banding for allocation under Part 6, nothing to do with Part 7, discharge.
Oh, 2 things going on here. Surely it's got a. One, you've been placed into Band 2, and we see the hinterland to that it was originally going to be Band 3, and someone took the decision to change her into Band 2. But it also sets out, as you've been accentuating earlier, the need for collaboration and cooperation and discussion and so on. It also deals with what properties that the borough say is suitable for her, and invites a response, cooperative response, if he doesn't agree. Which is why I started by asking you, to which the answer I think is no.
No, she didn't.
So what's the significance of that in the context of an ongoing collaboration?
Because the letter is a placement of banding under the allocation scheme Part 6. It is not reference to the assessed housing needs, or indeed what steps would be taken to relieve, to prevent homelessness, and connecting to the Part 7 duty. So this is an applicant who wouldn't be versed in the niceties of Part 6 and Part 7, the difference and distinction. She and the fact that non-response on a Part 6 could be taken as agreement to as to the needs under a Part 7 discharge. And my submission, my lord, what is required, when one looks at the structure of the Act, that when if there is a change, then there has to be a review. And then, so what this should have done, should have triggered a review of the assessment and plan, which would then have given the applicant the opportunity to put on notice that this is how the authority had assessed her needs.
You can't see the difference.
I can't. You've lost me, I'm afraid. Just
I mean-
in terms of people trying to get things done on the street, the woman who's faced with her vulnerable son, faced with homelessness,
Yes.
and the borough says, "This is what we're looking for you." Does it really matter that this letter can be interpreted as being provisionally sent under Part 6 rather than Part 7?
Because the discharge of the prevention duty can take place in a host of different ways, whether it be private sector or public or Part 6 allocation. So there are a variety of ways in which the Part 7 duty can be discharged. Part 6 is limited to looking at allocation pursuant to the allocation scheme and what the parameters of, in a sense, the banding and the criteria that will be used to identify what Part 6 accommodation.
If we look at the bullet points on 34,
My lord, yes.
of the criteria
Yes,
under this Part 6 process,
yes.
what is missing from what would be there under a Part 7 process?
What is missing is that that this is a review of our assessment of your needs under a section as required by Section 189A, and when it comes to discharge, we will be applying the same criteria when we're looking for accommodation, to identifying accommodation that will bring about the discharge of the duty.
Okay,
Because
so
it'll be
apart
different.
from those formal, well, what specific criteria, if any, are missing from this assessment of
What's missing
criteria as
is-
opposed to the assessment of needs under a Part 7 assessment?
What's missing in both the assessment and in the criteria that are identified is a question of location.
Right.
So
Which is what the judge found.
on suitability,
Yes.
it was suitable, like given its location. But at no point in the interview, or indeed in the banding letter, or indeed even though the issue was raised by the appellant that she had someone who provided assistance with shopping and cleaning the house and so on. So the issue had been raised that she had a network. That was an issue and that should have been addressed, wasn't addressed, and therefore it's and is an issue under the Code of Guidance. And the Secretary of State's advised authorities to look at the question of location as part of the assessment.
Location is mentioned in this letter, 2 or 3 lines down.
Or indeed, that
As a,
it could be outside the borough.
yeah,
Yes, but
or indeed outside London.
or indeed outside London. But there's been no assessment, as one would expect under 189A, of the question of location going back to what are the identified needs. There's as part of the assessment, there's no consideration of the importance of the support network and what would be the consequence of identifying accommodation in a location where that support network it disappears. And what would the effect of that be? Now, that is clearly a relevant factor that would be important to include within an assessment and a PHP, because it provides in a sense, the parameters, saying, well, actually, any accommodation needs to ensure that there is support network, given the vulnerabilities of the appellant's son and her own issues, medical issues, and so on, and the need for support. What is the effect of that? Now, we come to the question of what happens if there's a breach of if there's a breach of 189A because the assessment is deficient in that respect. I say that the assessment is deficient. It doesn't deal with that aspect, and indeed isn't looking forward and identifying what are the housing needs, and that would be one of her housing needs, is to maintain support, her support network, and to receive support, and it's not identified in the banding letter.
Do you criticise the way the judge dealt with this? Maybe you're going to come to this a bit later. I don't want to take you out of turn if you are. But the judge dealt with this at 52 and 53, didn't he, in the judgment? And
did.
proceeded on a certain basis.
He assumes on a certain basis that there
And that-
was that there was no lawful.
He assumes in your favour
It does.
on the point.
And I say he was right to.
Okay.
And the reason, and that, so my submission is that when it not only was the assessment deficient, not only was it there was no lawful discharge of the duty under 189A to carry out this assessment, but there was no review of it, even though they said it. It's not in writing. The assessment's not in writing because there is no assessment, and there is no agreement because there's no attempt to reach agreement with Ms. Fatolahzadeh as to the steps that have to be
It's
taken.
all good prejudicial stuff, but we've got to decide this appeal on the basis essentially of paragraphs 52 and 53.
Yeah.
So I can quickly, given the deficiencies and what I say is an unlawful assessment, then one moves on to the second question, which lies at the heart of this appeal, namely, was
So what?
is that it's the absence of a lawful assessment. Does that vitiate the decision, the review decision, or is the suitability? Does the suitability review discharge the duty because it deals with all issues and there's no requirement to comply with 189A before discharge of duty? As I say, my lord, and I've taken the lordships through it. So, right at the very beginning, section 195, subsection 3.
Can I
Places.
pose the question to you?
My
then?
lord,
This
yes.
seems to me the question you've got to address, if I may say so, is this. There was an assessment, albeit on the basis of the judge's findings, it was not complicit with 189A. But the duty we're considering is the duty under 1952.
Yes.
If it's the case that reasonable steps were taken, how does the deficiency in the assessment
My lord,
matter?
my lord.
Is that the question?
My lord, reasonable steps can only be taken where there is a lawful assessment. Because reasonable steps mean that authority can take action in the absence of complying with 189A, those are steps they can take, but in my submissions, they're not reasonable, because reasonable requires compliance with 189A.
But if the steps taken in practice correct the deficiency in the assessment, why is the test not then satisfied?
If the
Why is the requirement to exercise reasonable take reasonable steps not satisfied?
Because, my lord, that's putting the cart before the horse. That is saying that the suitability review that is undertaken, which addresses issues, for example, location, that overcomes and deals with the failure to carry out the assessment, and therefore the breach of 189A is of no consequence. And that is a step, I say, that's not a reasonable step, because it avoids, it enables local authorities to say, well, it's reasonable for us to assess suitability based on the facts as at the date of the review, and it matters not that we haven't carried out the assessment. That, to me, in my submission, isn't a reasonable step.
What would be your attitude if the appellant had walked into Barnet's offices and said, I've got a problem, I'm out on the 26th of September, and a housing officer had said, well, it just so happens, from what you tell me, you're probably band 2, and we've got just the place for you. And they go and they looked at it, and it's just the place, and it's just the job. And she says, I'll take it. Is that all unlawful in your analysis? Because you never get as far as an assessment, just serendipitous occurrence. As I understand your submission, that's unlawful.
My lord, yes, because, and the reason being is because the example that my lord has just given is, given the constraints on housing, is never, I've not yet ever seen where an applicant presents and is given a.
Well, with
an
respect,
offer
that's not a
That's not the point.
principled
I'm testing
answer.
the principle.
No, I appreciate that.
Yeah, but your submission, you firmly nail your colours to the mast of principle, which is that even though it is an entirely suitable house, and indeed the applicant wants it, the local authority would be acting ultra vires, because as a matter of public law, it cannot give that to her.
Well, my lord, as long as the assessment is in writing, and there are steps that are to be taken, that can be, compliance with 189A can be done in that scenario, that they can be satisfied. So applicant turns up and says, I need accommodation. They say we've got the perfect house for you. For them to say we've got the perfect house for you, they've got to have done some form of desktop assessment of what is the need and how the needs to be met, and then the matching, and then that will all be set out, and there is agreement that this is accommodation, these are your needs, we have the accommodation, are you prepared to sign up to it? Yes, and they sign up to it. So there will be a compliance.
Forgive me, but if the assessment is deficient in a specific way, which is corrected in the review process, in what sense can it be said that the local authority has not taken reasonable steps?
Because the correcting in a suitability review where there is identified breach of the 189A duty has denied the applicant the opportunity that was envisaged by Parliament when it enacted the scheme, this amended scheme, to identify needs at the very early stages of the application that will then determine whether or not an offer would be made. So once the plan is agreed and the assessments undertaking the plan is agreed, then an officer will come and match, will make it up. Their decision will be shaped by the plan. Once the offer has been made, and let's say that it's accepted but a review of suitability is requested, then the reviewing officer's review will be shaped by the plan, and then if that's adverse, then the county court appeal decision will be shaped by the plan.
So you're really saying that the whole process is collaborative. My word, that's really what you're saying.
Yes.
If you look at section 189A as a whole, it's a collaborative process.
Yes.
And a failure to comply with that vitiates any subsequent decision.
My lord, that was what Parliament intended. Otherwise, one asks the question, what's the point of it? Because if an authority can say, well, we let's say the example, authority accept they haven't carried out the assessment, or their assessment is unlawful because it fails to identify the housing needs, look into the future or identify the steps. And they say, well, yes, we accept we breached that, but we've offered you this accommodation and we've decided it's suitable. That then overtakes the breach, and the breach is of no consequence, and that's a lawful decision, which then renders the whole 189A purpose, the purpose of 189A as unnecessary and not to be complied with. The other alternative approach is that, well, if an authority, except they're in breach of 189A and they are judicially reviewed, then the authority can respond to that by saying, well, the way the scheme is to be interpreted is that, well, there is no requirement, there's no, that a breach of the duty is a breach of no consequence, because we are able to deal with it in terms of suitability assessments, which is what they've always been doing under Section 202 reviews and assessments by the County Court on point of law. So there'd be no change. There is no change. So the approach, if it is right that the construction of 189A and then the requirements in this case Section 1953 to have a regard to it when deciding how to discharge the duty, those are breaches of no consequence. So in other words, it's a judicial pen, red pen through 189A and the following subsections saying, well, it matters not. Suitability trumps the decision. And therefore, if it's a lawful decision on suitability, then the breach is of, as I say, of no consequence.
Suppose you're right, and the appeal is allowed. What happens next in practical terms?
Practical terms, the decision is quashed, and then there has to be an assessment on the housing needs, and then a further. And if the assessment were that this accommodation wasn't that the housing needs of the applicant were that she should be located in accommodation that is close to her support network, and this accommodation doesn't match that need, then the accommodation can't be suitable. And therefore, then the accommodation, the duty is not discharged, and the authority would have to make an alternative offer.
Could they, in fact make exactly the same offer again?
Sorry, my lord.
Could they, in law, make exactly the same offer again?
If there is if the assessed needs are that that there is no support network that she needs to be connected to, then yes, they could. But that would require the authority to assess whether or not location was a sensitive issue.
They've done that once already.
But they've done that in suitability review. They haven't done it as an assessment for the purposes of the 189A assessment.
But what's the material difference between those two exercises?
The material difference is that if it's accepted by the officer who carries out the assessment, that location is important and is sensitive because of the needs to have support network and be able to connect to the support network, then when it comes to a further review of the suitability, then the authority would have to say, well, we'll have to ask the question, how can this property, which doesn't enable the location or doesn't enable the continuation of the support network, how can it be a suitable accommodation? Because that's identified as a housing need and it doesn't meet it.
But that's why I asked you a moment ago, could they, on reconsideration, after this court has quashed their decisions, in fact come to the same decision? And now you seem to be implying that they could not.
It all depends, sorry my lord, I'm not making myself clear, it all depends on what the assessed housing needs are. Because under 189, they've got to look to the future and say, and part of the assessed needs, I say, is that Ms. Fatolahzadeh is able to maintain the support network and contact with the support network that she has. And that is part of her housing need. Now, if that's accepted by the council as being an important factor for identifying further accommodation that's suitable for occupation in discharge of the duty, then when it comes to the review of this accommodation, then I would say that it's not open to the authority to conclude it's suitable because it's contrary to the stated need. But if the need was, well, there is no need for location's not a sensitive issue, and you could be accommodated anywhere, either in or out of borough, then as I say, the plan helps both parties.
Have I understood this correctly? You say that an assessment carried out at that stage may lay the ground for a different finding on suitability of this property.
Yes, ma'am.
So whether that's a substantial submission or an abstract submission depends on, so far as we're concerned, on what we see of the terms of the review, request for the review, and how the review dealt with it. But there is no challenge to the way that the review dealt with suitability as such. Your ground is absolutely
Yes,
clean as a whistle.
it is. As I say, there was the challenge to the location. The judge found that it was suitable,
Dealt with on the review.
and therefore it was a lawful decision. And therefore it's within the scope of the exercise of the discretion that the authority have in determining what is suitable.
You're doing it very nicely, but you're trying to strain the leash that I think is imposed on you by paragraphs 52 and 53, and the fact of that you are not challenging the review.
I'm not challenging the review, I accept that, but I do say that the absence of challenging the review doesn't render the breach as a breach of no consequence. i.e., suitability review doesn't overtake and effectively wipe out the breach as being it matters not. If that is right, then that means, in my submission, Section 189A has no function, no material function, because local authorities can simply say we are going to undertake a suitability review, and that means any breach of 189A or failure to take it into account when discharging the duty under 1953 is immaterial, irrelevant to the discharge, because it's suitable. And that's why I say, my lord, I do nail my colours to the mast, the legal mast, that it renders Section 189A and the relevant subsections in 189B, 195 and 190 as being of no effect and have no point. The worst case scenario is where challenged before a review has been completed, that there is no assessment by a challenge by way of judicial review for breach of or failure to discharge the duty, the 189A duty, then my lord, the authority can simply reply in such a claim that either they've conducted the suitability review prior to the determination of the application on paper, or that they're in the process of determining suitability review, which means that one, there would be an alternative remedy, and two, it's a breach which has no consequence. So in other words, there's no effect, and that, I say, is not what Parliament intended. My lords, can I turn to Norton now?
Yes.
I appreciate I've gone over my allotted time. Probably.
What was agreed as your allotted time?
We hadn't reached an agreement. On
Well,
this.
then don't apologise for going over it.
Oh, well. My lord, can I turn to Norton?
More seriously, I will certainly expect you to finish this side of the short adjournment.
Yes, indeed. I certainly will. I certainly hope to be finished before that. My lord, turns, as I say, the decision of Norton, tab 14. My lord, picking up the facts at page 319 of the bundle, starts at paragraph 19. This was an acceptance of the main housing duty, 193, as opposed to either the relief duty or the prevention duty, or the limited duty under section 190. They made an offer of a private rented sector offer in discharge of the main housing duty. And as I said earlier, there was a challenge to that decision, and indeed a challenge by way of judicial review of the assessment, with the authority undertaking to carry out a revised assessment, but before making that assessment, they concluded that the accommodation was suitable. So, a situation similar to the scenario that I identified as an authority having a record being challenged for breach of the duty and making a decision on suitability, and then arguing that there's no need to comply with the duty because the suitability matches addresses all the issues that need to be taken into account in lawful discharge. Lord Justice Lewison cites and refers to the High Court authorities at paragraph 25 and 26, and then despite stating as he does at paragraph 31 that an assessment of suitability based on an unlawful or otherwise legally flawed assessment is in itself legally flawed, and in 32, no doubt that the assessment fulfills an important role in the overall framework for helping the homeless, rightly submitted that the assessment and the PHP provide the roadmap which will inform subsequent decisions.
Can I just put down this marker?
My Lord.
Are any of these, there are a number of first instance decisions which the Lord Justice Lewison addresses in the passages you've just taken us to. Are any of the facts of those cases on all fours with the facts of this case? So in other words, if this appeal if this appeal is dismissed, will we be overruling any of those decisions?
My Lord, no.
Because
they deal with challenges by way of judicial review of the failure to carry out the assessment, not as Lord Justice Lewison says, it doesn't deal with the question of what happens if there is a suitable, lawfully addressed suitability decision. So what Norton deals with is the position where the authority, despite the breach of 189A, carries on and carries out the assessment, and it's a lawful assessment. What is that decision vitiated by the breach of 189A?
So maybe I'm not making myself clear, or I'm confusing myself,
No, my Lord.
which I don't want to waste
My
time
fault.
your time by doing. But in the cases under review or cited here, so Mr. Bones, King's Counsel, Mr. Sheldon, King's Counsel, Queen's Counsel, as he then was, Mr. Dias, King's Counsel, as he then was, and Mr. Justice Lane. In each case, the assessment of suitability was flawed, is this right? Because they were based on flawed assessments.
These were decisions where there was a failure to carry out the assessment under 189, and they were judicially reviewed for breach of 189A and required to carry out the assessment.
Yes.
There was no subsequent discharge of the duty.
So if you can just be clear exactly what's going on in law.
Yes.
That's why their case is in the High Court
Yes.
rather than the County Court.
Okay.
Yes.
Because
indeed,
the appeal provision does not apply. But it is interesting. What it shows is that in principle, judicial review can lie, even at what might be called a preliminary stage
Yes.
in an overall process. And the answer wasn't immediately go away, wait for the outcome,
Yes. It was.
which sometimes it is, incidentally.
Indeed.
For example, if you're in the middle of a planning inquiry,
Yes.
and you try to challenge an inspector's ruling halfway through the inquiry, often you'll be told, go away, wait till the outcome is known.
I would say, my Lord, following Norton, that's the answer that will be given by the High Court. Go away and see what happens on suitability. That's why I say.
Well, hang on, I thought you were accepting, when my lord put it to you,
Yeah.
would we be overruling those earlier cases?
No, it
You
wouldn't
said
be
no.
overruling.
Conceptually,
overruling them.
well,
It's a consequence of.
that's your submission. I'm not sure it's necessarily correct in law that would follow. because it's a matter of what people argue in the future, but they will argue that despite Norton, those cases are still good authority because that was a situation where somebody did challenge by way of judicial review the failure to comply with section 189A. And that's why about an hour ago I was asking you a series of questions about what happens if you've had the opportunity to challenge, but you haven't done it. What does public law then say about a later stage in the process? Your submission is you can still challenge that earlier deficiency because it infects the later outcome in the process.
My lord, yes.
You appear to recognise that Norton may be against you on that, but now you're going to tell us why we should distinguish Norton.
Yes, my lord, yes. And the reason I say you can distinguish Norton is because if one turns to the conclusions at start at paragraph 45, page 326 of the bundle, has, as it often does, laid down an imperative requirement without specifying what the consequences of a failure to comply. And then over the page at 327, top of the page, not suggested that the reviewing officer's decision was based on a flawed housing needs assessment, that the point is a pure technical and procedural point. Paragraph 47. So before I go to 47, so the distinguishing factor here in this case is that I say the assessment is challenged. It's not a lawful assessment because of the absence of addressing the matters of identified in subsection 2, B and C. The assessment in the that is written down in the PHP is, even though it says it is the assessment, doesn't, when one looks at it and considers it properly, doesn't meet the requirements because it fails to comply with subsection 2.
Is this point also important? But you may be coming on to this, but I noticed that in paragraph 47,
I'm coming on to that now, my lord.
forgive me, you make your submission.
My lord, yes. The second distinguishing factor is the fact, and it's an important distinguishing factor, and that is in section 193, there's no requirement to consider the assessment. As Lord Justice Lewison identifies, as is shown, and I've taken my lords to section 189B, 190 and 195, the relevant subsections which expressly require that it be considered, whereas in section 193, so there's no such cross-reference in section 210. My lords will find it's in the bundle, but it's also cited by Lord Justice Lewis in section 210 at para 13. And indeed, he goes on, section 193B6 suggests that the authority is not confined to making decisions based on the section 189A assessment. And we can see the section 193B6 is in paragraph 15 over the page at the top of the page of the quote of the from the section itself, and the words "or not" are to be interpreted as in paragraph 16 as suggesting that in making the decision it's not confined to a section 198A assessment. So there is a distinction being drawn between 193 discharges and discharges under 189B, 190 and 195. And that's the point that Lord Justice Lewison draws out, particularly His Honour Judge Sigerson's decision being right that it doesn't, there's no duty to consider the 189 assessment, although he's free to do so, or if it is relevant.
A crucial element in this analysis was the decision in AI, wasn't it? And
Yes. So having accepted that there is no requirement, before we get to the AI decision, the A1 decision.
A1, sorry.
A1.
A1, I was.
My lord, the paragraph 49, applying the A1 properties, the approach in A1 properties, Mr. Norton has lost nothing of value. And that's because there was it was not suggested that there was a flaw in the housing needs assessment. We, in this case, I say that the case has always been that there is a flaw in the assessment. There is no lawful assessment carried out, and Ms. Fatolahzadeh has lost something of value, and that is the ability, as what Parliament intended, the ability to meet with the authority right at the very outset to agree what steps had to be taken in light of the assessment, and that is an important opportunity that Parliament has given this to all applicants.
The kernel of that A1, I think, is the passage from paragraph 61 in Lord Briggs and Lord Sales' judgment, quoted at paragraph 39
Indeed, my lord.
in judgment. How would you interpret your case here by applying the framework in that paragraph?
My lord, the focus is on the purpose served by the requirement.
Yes.
So one's looking at what the reason why Parliament intended, what the purpose of the assessment is for,
Yes.
and how it is to be used by the authority when deciding how to discharge the duty by providing securing.
So how would you define the purpose served by the section 189A requirement here?
My lord, the purpose is to provide the framework against which the authority and indeed the applicant will be working together to identify and secure suitable accommodation.
Can I rephrase that for
My
you?
lord.
See whether you accept it. The purpose is to minimise the risk of unsuitable accommodation being offered.
That would be a flip to is the other way of looking at it, I suppose, is to knock out that which is, it would be to identify, to enable an authority to be able to identify that which is not suitable.
Okay.
So it's looking at the housing needs of the applicant, using the wheelchair-bound applicant, and saying unlifted accommodation is clearly not going to be suitable. So
What about B in Lord Briggs and Lord Sales's framework? How would you analyse the focus on specific facts of the case having regard to whether any and what prejudice or injustice might arise, if it's affirmed, notwithstanding the breach of section 189A?
My lord, the prejudice and the injustice is demonstrated by the fact that the cart's been put before the horse.
Well,
that there has been, in the absence of a lawful assessment at the very outset, the applicant is then presented with an offer, which is then subject to review and decision based on. So there's been no input into the identification of the property that is then offered and then subject to suitability assessment.
if the outcome is your client has been provided with suitable accommodation, what prejudice has she suffered?
The prejudice she has suffered is the lack of opportunity to engage and to be involved in the identification of what accommodation would be considered to be suitable, the criteria that would be applied. So if, for example, the authority are and the applicant agree on a certain parameters, then those parameters will then determine what the allocation officer will be looking for.
Isn't that the whole point of the review process?
The review process
says I don't like this house, but what you say it's suitable, but it isn't suitable because you haven't taken account of location. Go away and think about location. Come back with an unimpeachable decision on covering that. That's the system, isn't it?
My lord, that's the way the system used to be.
Well, that's the way the system works at the moment.
Well, that's the way the system worked prior to the amendment introduced by the 2017 Act, because the council, the authority would identify the accommodation, they considered it suitable. They don't have to give reasons for why it's suitable. They make the offer, then the applicant says it's not suitable because I request a review, and then the authority make the decision on review, it's suitable. And then there's an appeal against, potential to appeal against that to the county court. That's the old system. The new system, following the introduction of the amendments from the Homelessness Reduction Act, front loads the assessment so that which has an impact on the identification of the property.
So it really comes down to this, the crucial factor of the collaboration.
Involvement and collaboration.
Yeah, and that is prejudicial within the meaning of Lord Briggs and Lord Sales's framework,
It's denied
even if the end result is accommodation that your client is satisfied with.
because the conclusion of, well, suitability review overcomes the difficulty, the breach, is that it effectively means that the old system, i.e. not as amended by the Homeless Reduction Act, continues to be good law.
But she gets a suitable accommodation.
But my lord, if the opportunity that's been lost is the opportunity to engage, for the applicant to engage with the authority and the authority to engage with the applicant to identify what accommodation would, what the needs are, so that when it comes to identification of the property, those needs will in a sense assist the authority to identify what is suitable, and that's what's been lost.
Mr. Colville, I wonder if you could cast your argument in very conventional public law terms. In many contexts of public decision making,
Yes.
planning is an obvious example,
Yes.
but it could actually be in any public authority decision making context. In that area of law, it's well established that you have to take into account all material considerations. And it wouldn't necessarily be an answer to a legal challenge on the basis that there was a failure to take into account a material consideration, that the outcome is going to be the same. The relief is still discretionary,
Yes.
so it might be a reason for declining to give relief.
Yes.
But nevertheless, public law does place an importance on going through the correct steps.
Yes.
In other words, there's a distinction of principle between process and outcome. The mere fact that the outcome is likely to be the same, or perhaps inevitably will be the same, doesn't necessarily mean that there hasn't been a breach of public law.
Indeed, my lord.
But sorry. So is that the analysis that you're invoking here? Because we've been told by Parliament that we don't have to guess or speculate. We've actually been told in terms by Parliament that this is a mandatory relevant consideration. And your submission, I think at its simplest, is that if this doesn't really have any legal consequence, then Parliament acted in vain in 2017 because the law hasn't changed. That's your submission. I'm not saying I agree with it.
No,
That's your
my
submission.
lord's quite right. That is, what the only point I would make on the back of that, my lord, is that it's not inevitable that the same decision would be made.
Yeah, well, that's an, if I may respectfully say so, that's an important further submission, because this is the point that's often made in the planning field, for example, that it's not what you get at the end of the day. It is that actually if the local authority had to reconsider and have regard to all relevant considerations, it might in its own expert judgment come to a different view.
Oh, yes.
So in other words, the court is not substituting a different outcome, but it is saying to everyone that you've got to go away and do this all properly.
Yes. And Parliament expressly requires, in the context of 1953 decisions, that this assessment, it has to be a lawful assessment, and two, that assessment has to be taken into account. Now, if it's not a lawful assessment that's been carried out, then it's in breach because it can't take it into account because it's not.
That's the analytical step that speaking for myself, I have more difficulty with, because if you simply argued that they failed to have regard to a material consideration because they failed to have regard to their own assessment, I could understand the argument. But actually you have to go further. You have to say that even though the assessment could have been challenged, was not challenged, and they did take it into account, that they have acted unlawfully at the end of the whole process because the assessment was legally deficient.
Yes.
That's your argument.
It is.
Right, okay. That's very helpful, thank you. Now, how are we doing for time?
I'm thinking coming into land.
All right.
There is an importance in terms of order. Looking at the order of way things should be done, Parliament requires the assessment to be completed before any decision is made as to discharge. So the correct order is in place, namely first carry out your assessment, then determine what duty, if any, and how that duty is to be discharged. And in the context of a prevention duty, or in the relief duty, or in the discharge of the limited duty under section 190, they are required to take that assessment into account. The facts in the approach of the court in Norton can distinguish us from this case, because this is a discharge of relief which Parliament has expressly required the authority to take into account as part of their assessment. And it is not inevitable that because a property is considered under review in the absence of the assessment, that is a lawful decision, because the assessment would find and conclude that the housing needs of the applicant are met by the property that has been offered, and the steps taken to secure that accommodation are steps consistent to discharge of the duty to secure suitable accommodation. In my submission, one can't wind back the time and say, well, if the decision was the assessment was now carried out, it would conclude, with the hindsight and looking back retrospectively, it would conclude that this property is property that meets the housing needs of the applicant. The applicant is entitled to the correct order of steps being taken as required by Parliament, and the authority here have failed to do so. The final point is that the decision was a discharge of the 195 duty because the property is suitable, which ties in with the way in which the section provides for discharge and bringing the duty to an end. It is not open in my submission to argue that, well, this was a suitability assessment and therefore following Norton it's limited to, it's possible to argue that Norton applies because this is a suitability assessment as opposed to a discharge decision. The discharge is, as we can see from the review decision itself, the discharge is linked to the finding of suitability, and they are inextricably linked. So one cannot split hairs and say, well, because this was a suitability review, it follows that the requirements of 1953 don't engage and don't apply, and therefore the court should follow Norton.
I'm very sorry, I don't understand that submission, and I'm sure it's my fault.
I apologise.
And it's really your grounds of appeal.
No, just as an ancillary point that I'm making,
Okay.
it may be argued that because it was a decision based on suitability, therefore the requirements of 1953 and the discharge follow and were not therefore part of the review. So one can divorce the requirements of 1953 from the suitability assessment, and therefore, if that were the case, the requirements of subsection 3 don't apply, and Norton can apply. Namely, there was nothing within within suitability assessments that require consideration of the 198A assessment. What I'm saying is that you can't divorce the suitability review and the discharge from the discharge. They are hand in glove. They're inextricably linked. It follows on from the finding that the property was suitable, that there is a discharge. That just follows on as a matter of construction, and therefore
And they sent a discharge letter.
They sent a subsequently discharge letter, but the review letter, which is under challenge, says this is suitable in discharge of your duty. So it accepts that there is a inextricable link between the two, but then there's a subsequent discharge letter saying, given what we found, we've discharged the duty. But the assessment of suitability is in context of 195 and not separate to. And therefore the 1953 obligation is engaged. My Lords, I think in my skeleton argument I've referred to the criticism in respect of the PHP and the failure to undertake a update of the review. My Lords, I think I've covered the points already. The points are made already in my skeleton, and I've dealt with them orally. Don't wish to repeat myself. My Lords, and for those reasons, unless I can assist any further, those are my submissions.
That's been very helpful. Thank you, Mr. Cole. Now, Ms. Screech-Powell.
Thank you, my Lords. My Lords, I'll take my submissions out of order from my skeleton arguments if I may, and deal with Norton first, because
Yes.
it is Barnet's submission that actually Norton provides most, if not the entire answer to this appeal. So I'll be making sort of 4 main submissions. Whilst there is a dispute between the parties as to whether or not needs were assessed and reviewed, I say on the facts of this case it's actually immaterial. As a pure point of law, it is not a consequence which invalidates the suitability review decision, and I say Norton is the answer to that. If I need to go beyond Norton, perhaps, my Lordships, I do in relation to paragraph 31 of Norton. I say the suitability review cures any deficiency, and for that I rely on the case of Appellant against Westminster, which I'll take you to when I deal with that part of my argument. Mr Colefield has foreshadowed one argument. My third point, if you like, is that this was in fact a suitability review. The discharge of the prevention duty notification came later, and there was never any request for review of that decision. But also, perhaps more fundamentally, which I say puts the appellant's argument in even bigger difficulty, is that there was never any request for review of the steps the local authority proposed to take in performance of the prevention duty. That is a reviewable
So
decision.
could you say that again? I didn't quite catch that.
There was never any request of the steps the local authority proposed to take in performance of the prevention duty. That is a reviewable decision. It does carry review rights, and no request was ever made.
What was the date of that? Just remind me.
So the acceptance of the prevention duty and the personal housing plan, which set out the steps the local authority proposed to take, were on.
By all means, come back to that question at an appropriate juncture.
It's 26th September 2022.
Was that the letter we were shown earlier today, which did have a sentence saying that you may ask for a review of this?
No, that was a different letter. That was the
Ah.
banding decision letter.
I see. But,
So-
but you say that a review could have been sought of that,
The review could have been
although you weren't told that.
They were told.
Oh, they were told that.
I'll double check. I think I've got
Right,
that
nice.
right. I think it's.
Nice.
I'll double check that.
Okay.
I'm sure I've got that right.
Okay.
I'm like questioning myself because your lordship's perhaps spotted something I
No,
haven't.
no. It's a genuine question. Probably moved by ignorance.
I will check, and I certainly won't be making that submission if I'm wrong on that.
So that's your third submission.
That's right. And then my fourth submission is, and I do say actually, we might even need to get into this, but actually needs were assessed. Judge Hellman didn't find that the needs went unassessed. What he did find, he made a finding that the needs were assessed, but actually that the assessment was insufficiently reasoned when it came to location. And I do say that there is a distinction there.
I see. And that's a very helpful structure to your submissions. But are you or are you not making any submission about inevitability and discretion of relief?
I am.
Ah.
I was sort of sweeping that up in my fourth submission, which is actually there is no extant complaint about suitability. And so even if the court is against the respondent on the needs assessment, the court shouldn't grant relief. So if I pick up on the first point, if the needs weren't assessed or weren't properly reviewed, in my respectful submission, there has been a slight shift in the position of the appellant here, because the argument had been in the skeleton that the needs went unassessed. I don't understand that to be the argument now, but weren't lawfully assessed. So there was some assessment, but not lawfully assessed.
It was. I think it said it was deficient.
That's right.
Right.
And on A's analysis is sort of a pure hard-edged question of law. If there was a deficiency, that invalidates, it really invalidates everything thereafter. It's any steps taken, but also on his submission will also invalidate a review decision on suitability. And I do say that Norton provides the answer to that. You've already been taken to it, so I don't think I'll need to take you to it again, apart from the one paragraph at 31, which your lordship picked up on. But Norton confirmed that the approach of A1 properties apply and the approach of Singh apply, that what the court is looking at is the emphasis should be on the consequences of non-compliance. Did Parliament intend total invalidity if there had been any sort of deficiency? And in doing so, one's looking at what would be the alternative. In other words, is there prejudice caused to an applicant if in public law terms, has there been prejudice caused to an applicant if there has been some sort of deficiency?
Well, Mr. Cole, in the end, majority, if I don't mean to, I think Mr. Cole's case is that the lack of collaboration, the lack of the engagement in the agreement process provided for in section 189A was contrary to the purpose, using Lord Briggs and Lord Sales's framework, the purpose served by the requirement, as assessed in the light of a detailed analysis of the particular statute, and on the facts of the case,
Well,
was prejudicial. The absence of any process of collaboration and agreement.
so my answer to that would be, well, actually, there is collaboration throughout, because of course the appellant or a disappointed applicant does always have a right to request a review. Now, the review of the decision is a review of all the matters as at the date of the review. So the applicant can bring to the local authority's attention any matters that it considered went unaddressed, any aspect of suitability, but not just suitability. It could have been said, how can you possibly be satisfied this was a suitable offer because you haven't lawfully assessed my needs? And then it would become a consideration.
Where do we, are you going to refer to us in places in the papers which show this collaborative approach being adopted sufficiently?
Yes, Your Honour, I would say, oh sorry, my lordship, yes, I would say the interview itself, which we find in the supplemental bundle, thank you, at 242.
Okay.
And I say that fully engaged with the applicant.
247.
247. She's asked questions about her circumstances. It looks at the reason for homelessness, which is one of the matters of section 189A. It looks at who she's presenting with her son, her adult son. I'm looking at page 248. It looks at their employment circumstances, the fact that neither were employed. It looks at where they're currently living. And you'll see, to begin with, Your Lordships, at 248, the client wished to remain in the property and was advised that we will try to sustain the tenancy. I'm going to come back to that on my point 3, which is, if we're talking about the review, the significance of what is actually being reviewed, because I do sort of nail my colours firmly to the master and say this was a suitability review. It wasn't a review of the steps the local authority was taking, it was a suitability review. Further down, we have more details about, at page 249, about the family itself, but at the bottom of page 249, questions are made about the adult son and his education. Over the page, questions about benefits, which is obviously significant because then that feeds into affordability and what the family could afford. But then from 250, I say that is where location then starts to be addressed, because they're looking at where the local GP is, any medical matters that are relevant. Pausing there, my lordships, about halfway through engaging with support, the answer there says no. Do you provide care for support or anyone, again at 250? No. Over the page, any mobility issues, son has adjustments made in the bathroom, so I say that goes to the household's needs. And then about halfway through further suitability assessment, support networks, yes, friend Nushan Taram Judge, she assists with client and son with their needs. Her friend provides her with support weekly with shopping, appointments and cleaning in the house.
Relevant to location.
Yes, yes. Just to highlight, attend a place of worship, the answer is given no, but in fact we know by the time it gets to review, one of the things that the appellant is saying is actually, I go to an Iranian Christian church and that they're also a support network. I'm highlighting that now because what the court hasn't been taken to is the review decision itself, and I say these were all matters that, once further representations were made, were all addressed in the suitability review decision.
Including support network.
Yes, yes.
Can I just check on something which I think I should have checked with Mr. Coley? The section 202, right to review of decision,
Yes,
BC
yes.
is the one that we need to keep an eye on, not just the suitability requirements, because BC covers any decision of a local housing authority as to the steps they are to take under section 2 of subsection 2 of section 195.
Yes.
Would that include a failure to issue an assessment?
In my submission, no, because the reasonable steps are the steps the local authority are going to take to help.
Having regard to the assessment.
Having got yes, but it's the reasonable steps they're going to take to help an applicant to retain their accommodation. We're talking about prevention at the time, so to help them retain accommodation. So I say no, although of course you can seek a judicial review of an assessment, and I will say why that distinguishes all the other cases in the administrative court, YR, XY. They were all interim decisions, section 188 interim accommodation, where there's no statutory right of review, and they were all challenging the lawfulness of the assessment itself, in contrast with this case, where there was never any challenge made.
So, as a matter of fact, the review is asked under F or G or whatever it was, suitability.
Yes.
In what circumstances would you have a request for a review under BC?
So that would be any steps the local authority is going to take in order to prevent an applicant from becoming homeless. So to give it sort of practical context, supposing a local authority said you need to raise a deposit so you can find accommodation in the private sector, and the applicant said, well, hang on a minute, I'm not working, I'm on benefits, I'm a carer, I can't take that step. They could then seek a review of that step. Other steps might be you have to go and look at properties, you have to visit 3 properties a week to try and find your own accommodation. And the applicant might say, well, I'm in a wheelchair. So those are the sorts of steps I would say.
Thank you. Okay.
The answer you gave a moment ago to my lord about the High Court cases we know about,
Yes.
and the stage of the process at which those challenges were brought, it might be said that that also provides, at least in part, the answer to the question, has the enactment of section 189A made any difference to what went before? And I think you would say, yes, it has, because if a local authority either fails to discharge that obligation at all, or does an assessment which is deficient, it's amenable to challenge.
Yes, I would accept that, yes.
That's not of no consequence.
No.
The law hasn't been enacted in vain, because it allows you to do something by way of challenge which previously the law did not allow you to do, presumably.
Yes, I would adopt that. Yes, that is right. Because one of the arguments being made is, it matters not, but it matters not for that very good reason. But also, actually, if take this case as an example, when the suitability review request was made, even then the applicant could have said, well, hang on a minute, your whole, how could you be satisfied that was a suitable offer because your housing needs assessment was inadequate? That would then give a local authority a chance to look at the housing needs assessment, and it might consider, yes, that's a relevant factor that ought to be taken into account on the review. A housing officer might take the view, a senior, I should say, the reviewing officer, because that's also quite important here. A senior housing officer might take the view it made no difference, or it might say, yes, you're right, there was a deficiency, I'm going to give you a Minder to letter, and you can make further representations about why I see the offer is still suitable. So I still say there's lots of protection already built into statute.
Thank you. Now, that clock is 3 minutes slow, as it happens, so it is in fact 1 o'clock. Can I just check how much longer you think you'll need?
I don't think I'll be any longer than 45 minutes.
Very good. We won't hold you precisely to that, but that gives me a rough idea. That's very helpful. So we will resume at 3 minutes to 2 by that clock.
Thank you.
All right, over.